Welcome back, and let's take you back to court, where those executives that were arrested by the NPA and the Hawks are appearing at the Palm Ridge Commercial Crimes Court. Let's take you there live.
You won't be making any appearance before this court, but it's for purposes of the other process, the extradition, that their names are included in the charge sheet. Then the other entity was sorting out, he will be here before, but on the charge sheet it's redacted. His name is not there, but it will be sorted out before the next appearance. The court pleases your worship. The accused before the court, their first appearances, they are represented by Mr. Ulrich Roux, Advocate Dolphin for accused number 9, Mr. Molefe for Mr. Molefe, and Mr. Singh for Advocate van der Heever. It's their first appearance, and they are going to apply for a bail application. It is a Schedule 5 bail application, and it is unopposed. My colleagues have prepared affidavit for that purpose. So the court pleases.
Your Worship, may please the court, sorry to jump up. I think the accused are standing in an incorrect order. I think Mr. Singh is accused number 8.
That's right.
Yes, so they are start.
Mr. Singh? Who is Mr. Singh? You have to be the first one on the side. And then followed by Mveliso. Who is Mveliso? Right. You follow Mr. Singh. And then Mr. Molefe. And then Anoj Singh. No. Something is not right here.
Now, Mr. Pillay, I think.
No, it's actually Mr. Pillay who is supposed to be the first one on that side.
Oh.
The previous order was correct.
Oh. And the only reason why I asked is because my learned friends informed me on Friday that, and put it in an email, that accused number 8 will be Mr. Singh. That's why.
Let's just make sure Niven Pillay is accused number 8 according to the charge sheet. And then the Beliso is number 9. Then number 10 is Regional Capital, the corporate entity. And then number 11 is Mr. Molefe. And then number 13 is Mr. C. Right. All people around this area, or preferably in the whole courtroom, can you just switch your cell phones off? If the cell phone is very close to the recording machine, it has got a very disturbing effect on the quality of the recording. So anyone around the microphone, just make sure your cell phone is off. Mr. Roux, for accused number 8, are you ready to move your application?
Thank you, Worship. I am indeed.
May then proceed.
Thank you, Worship. I confirm my appearance on behalf of accused number 8 before court today, Mr. Mbalenhle Mthethwa.
Right, before we proceed, gentlemen before court, let me inform you that in terms of section 157 of the Criminal Procedure Act, you are joined as accused number 8, being accused number 8, 9, 10, 11, and 12 respectively. Accused number 10 is a corporate entity represented by accused number 8, I think. So you'll be joining the other accused from now henceforth. You may then be seated. May then proceed, Mr. Roux.
Thank you, Worship. Your Worship, I have prepared an affidavit on behalf of accused number 8, if I may read that into the record.
May proceed.
In the Regional Court for the Regional Division of Gauteng, held at the Specialized Commercial Crimes Court, Johannesburg, sitting in Palm Ridge, in the matter between Niven Pillay and the State, this is an affidavit in support of bail. I, the undersigned, Mbalenhle Mthethwa, hereby state as follows. I'm a businessman and director of companies residing at apartment 12004, 53 2nd Avenue, Houghton, Gauteng, Johannesburg, Gauteng. I am presently 56 years of age with identity number 66040251188087. The facts contained herein, save where expressly indicated to the contrary, are within my personal knowledge and belief and are both true and correct. I have deposed this affidavit of my own free will, and I have not been unduly influenced in any manner to do so. I am an accused in the criminal case referred to above. I deposed this affidavit without having clarity pertaining to the exact charges that I am faced with, and I have no certainty pertaining to who the co-accused in the matter are. The nature of this application. This is an application for my release on bail pending the finalization of the criminal trial. I have not had sight of the charge sheet in this matter, but understand that the charges to be preferred against me pertain to alleged fraud and/or corruption. I have been advised that due to the nature of the aforesaid charges, my application for bail fall under the category of a Schedule 6 offence in terms of Section 60, subsection 11, subsection B of the Criminal Procedure Act 51 of 1997 as amended. I accordingly bear the onus to prove exceptional circumstances exist which permit my release on bail. The purpose of this affidavit is to provide the Honourable Court with my personal circumstances and to address the allegations levelled against me insofar as they are known to me, as well as to address the factors to be considered by the above Honourable Court as provided for in Sections 60 subsection 4 to Section 60 subsection 9 of the Act. I respectfully submit, as I will demonstrate herein, that the interest of justice permits my release on bail. In any event, the dictates of fairness and justice, in view of the peculiar facts herein, warrant that I should not be deprived of my liberty. Personal circumstances. I am a South African citizen with identity number as reflected above. I was born in Chatsworth, Durban, KwaZulu-Natal. I hold a Bachelor of Science degree in Electrical Engineering from Princeton University and a Bachelor of Public and International Affairs from the Woodrow Wilson School at Princeton University. I obtained both of these degrees in 1989. My wife, Shana Pillay, and I were married in the year 2000, and we have two children, a son who is 24 years old and a daughter who is 20 years old. I have been permanently resident within this court's jurisdiction since 1989, with the exception of a 3-year period during which I worked and resided in London. I deal with this herein below. Prior to my current abode, as stated above, I resided at 44 8th Avenue, Houghton. We have accordingly resided as a family in Houghton, Johannesburg since 2004. Both my children are presently university students in the United States of America. Both are currently renting accommodation. Until the 3rd of May 2022, their study and living expenses were funded by the Pillay Family Trust by means of a distribution of themselves as beneficiaries of the trust to themselves. This is in accordance with the primary purpose of the trust. I have two siblings. My older brother is 57 years old and has been resident in Johannesburg with his family since 2006. I share a close familial bond with him. Apart from this, and in terms of our Indian heritage and culture, I have the utmost respect and trust in him by virtue of his position and standing in the family. I lost my father in 2006. My brother has assumed his role as the head of the family. In this regard, his wisdom has always been referred to. My mother is 72 years old and resides in Chatsworth, Durban, in our parental home. This property is registered in her name since the passing of my father. My mother is supported financially by her children. As a family, we share a close-knit bond. In addition, I have more than 100 greater family members, in brackets, cousins, aunts, uncles, etc., residing in Johannesburg, Durban, Cape Town, and Port Elizabeth, whom I am close to and regularly interact with. I regard South Africa as the country which embraces my most important familial ties as detailed above. Apart from the family ties, I also have strong spiritual ties to the Republic. I embraced this culture from my grandfather, who was the founder of the Clarewood Hindu Temple in Durban in the early 1900s. I've continued with my religious and spiritual beliefs through the Melrose and Midrand Hindu temples. Apart from being such a staunch supporter, I also financially contribute to the development and upliftment of the Hindu community through the temple. In addition, my family is often called upon to be part of the officiating ceremonies. Travel and travel documents. I hold only a South African passport issued to me on 30 September 2020. In 2021, I handed this passport over to the investigating officer in a pending matter in the Johannesburg Magistrates Court, as it was a condition of my release on bail in that matter. At an appearance during March 2022, the court ordered that the passport be returned to me to allow me to travel and later so that I may apply for a USA visa, which I am currently in the process of doing. I've paid an additional bail amount as security until the passport is returned to that investigating officer. I have, however, handed my passport to the investigating officer in this matter, Colonel Kutsia, on 29 August 2022, this morning, and it is currently in his possession. Employment history: I started as a management consultant with Anderson Consulting and Deloitte Consulting during 1989 and 1990 respectively. I thereafter joined Standard Merchant Bank to start up the interest rate products business. By 1994, Standard Merchant Bank, under my leadership, developed and enjoyed a 70% market share in the business. In late 1994, I was appointed as Director of Derivatives. In 1995, I left Standard Merchant Bank to spend 4 months with Investec Bank, where I was responsible for cross-market structuring. After leaving Investec, I spent 1 year establishing trading operations for ABN AMRO in Johannesburg before being transferred to London to start up the emerging markets derivatives business. After 3 months, I joined UBS in London as Executive Director of Emerging Markets Derivatives. In 1999, I returned from London and started at WIP Capital, where I held the position of Executive Director and Head of the Structured Markets Division. In 2002, I established Maya Capital, focusing on strategy consulting, risk management consulting, and derivatives trading. This business model later became a substantial part of the business structure of Regiments Capital. I acted as a Director of Regiments Capital Pty Limited from 2004 until a liquidation order was granted in 2019. I still hold directorships in various subsidiaries and associates of Regiments Capital Pty Limited. Aside from the period of study and work in London, I have resided in South Africa my entire life. Assets and income: I own the following assets valued at original cost to me. All of the assets currently in my possession are subject to curatorship. 2 family motor vehicles valued at 3 million rand, household effects valued at 1 million rand, and equity investments, listed and unlisted, valued at 5.3 million rand. I supported myself and my family with income earned from the subsidiaries and associates of Regiments Capital for many years. However, more recently and until 3 May 2022, I have relied solely and entirely on distributions from the Pillay Family Trust. The Pillay Family Trust is currently under curatorship pursuant to a restraint order granted ex parte by Judge Wright in 2019, discharged by Judge Mbalenhle in 2020, and confirmed by the Johannesburg High Court on appeal on 3 May 2022. Consequently, I am currently unable to fund my living expenses and my legal costs. Both the NPA and the curator require me to apply to court for an order to release restrained assets for these purposes under circumstances in which I am unable to fund the legal costs associated with the application itself. The charges: as reflected above, I have been advised that the state intends preferring charges of inter alia fraud and/or corruption. As mentioned, I have not been provided with a charge sheet or copy of the police docket yet, and I am therefore not in a position to provide the Honourable Court with any detail relating to my defence in the matter. I however deny that I have conducted myself in any unlawful manner, either as alleged by the prosecution or at all, and I intend to plead not guilty to any charges that may be levelled against me. I wish to further add that Transnet SABC conducted an extensive investigation into the subject matter of this case, running over more than a year, utilising MNS attorneys. I provided my full cooperation during this investigation and understood that it was clear to the investigators that I was not implicated in this matter. I am therefore extremely surprised that I have been charged. Criminal record: I have been advised of the provisions of Section 60, subsection 11B and A, and I am aware that if I provide false information regarding my previous convictions and/or any pending cases, that it is a criminal offence, punishable by a fine of up to 40,000 rand or 2 years imprisonment. I confirm that I have no previous convictions. I currently have a pending matter in the Johannesburg Magistrates Court emanating from charges brought against me in 2021. This matter first came to my attention in 2014, during which I offered my full cooperation to the National Director of Public Prosecutions and made comprehensive representations, inclusive of supporting evidence, to the National Director of Public Prosecutions. As with the present matter, I was surprised to have been charged in this matter, since I have received no response to my representations as yet. As a result, I have applied to the High Court to review the decision to prosecute me in this matter. Despite having had more than 2 months to do so, the National Director of Public Prosecutions has so far failed to provide the record of decision. I require funding to bring an application to release funding from my restrained assets to pursue this review application further. I deny the charges against me in this matter and deny any unlawfulness on behalf pertaining thereto on my behalf. The provisions of Section 60, subsection 4, subsection A to E. Your Worship, would Your Worship like me to read the provisions into the record of that section?
It's not necessary.
Thank you, Your Worship.
That you can address in argument if you want to.
Thank you. Your Worship, then I've known of possible charges levelled against me for some time. Upon becoming aware, I offered my cooperation to the National Director of Public Prosecutions in writing through my erstwhile attorneys. Despite the aforegoing and knowing very well that an arrest may be effected, I nevertheless travelled outside the country and returned each and every time. I respectfully submit that under these circumstances, it is clear that if it was my intention to abscond and not to stand my trial, I have had ample opportunity to do so. Confident that I will be acquitted at trial, I have always elected to return to the Republic and face my arrest whenever affected by the state. I have indeed voluntarily surrendered to the investigating officer this morning when I was informed that the investigating officer intended to arrest me and requested my attendance at his offices at the relevant police station. I have always had and still maintain a very close relationship with my family in the Republic, and I have no intention of living the life of a fugitive from justice and from my family for the rest of my life. I understand the severity of the charges preferred against me and the severity of the possible sentences if convicted. This does not deter me. I give the Honourable Court my absolute assurance that I will adhere to my bail conditions and to stand trial if released on bail. I respectfully submit that I am not a flight risk, and any suggestion that I pose a flight risk is devoid of any truth and not bona fide. At this point in time, I am still prepared to assist the State and the investigating officer as far as reasonably possible. Furthermore, if granted bail, I will continue to reside at my permanent address as stated above. I have further been advised that in considering the grounds in Section 4, subsection A to E of the Act, that this Honourable Court will decide the matter by weighing up the interests of justice against my right to personal freedom, and in particular the prejudice that I will suffer if I am detained to custody, by taking into account the factors enumerated in Section 60, subsection 9. I am advised that my attorneys cannot prepare my case properly if I am in custody for the following reasons. When considering the allegations by the prosecution contained in founding papers in order to obtain a provisional restraint order in terms of poker, it is clear that the trial against me and others will be an extremely complex and lengthy trial. I am advised that a trial of this nature will probably last for many months. I am further advised that the preparation for such trial will be complex and lengthy. It will be extremely difficult, if not impossible, to properly prepare for such trial under circumstances where I am incarcerated. I will have no part in delaying the trial, and I do not suggest that anyone on the state side will have any part in causing a delay. I am advised, though, that it is simply inherent in the nature of the charges against me that a lengthy delay is to be expected until the trial is finalised, as I am not the only accused in this matter and there are other legal representatives before court. I need to be gainfully employed and work in order to support my family and to finance the ongoing legal expenses relating to the litigation against me. My continued detention and the loss of income that goes with it will also limit my ability to pay for legal representation. I will thus be seriously prejudiced by my further detention in prison, and I respectfully submit that a proper case has been made out and that it is in the interest of justice to release me on bail pending the finalisation of the prosecution against me. I further submit that exceptional circumstances exist which permits my release on bail, given that the investigating officer in this matter, as well as the state advocate on behalf of the NPA, are not opposed to my release on bail, and that this matter predates the pending matter, which is currently under review in the Johannesburg High Court. In the premise and taking into consideration the relevant schedule the charges resort under, I respectfully submit that I have discharged the required onus and respectfully request that this Honourable Court should grant me bail in an appropriate amount and with such conditions attached as the Court may deem fit. Your Worship, this affidavit was signed by accused number 8 on this day and also duly commissioned on this day. If I may hand it up to the Court, Your Worship.
Stand up, Mr. Pillay. Do you confirm as correct what is contained in the statement?
I do.
Thank you. You may be seated. Shall be Exhibit G. Any more evidence for the accused?
Thank you, Your Worship. That is in the case made out for applicant 8 in support of bail, Your Worship.
Thank you. Advocate Doflin for number 9.
May it please the Court, Your Worship, I confirm my appearance on behalf of accused number 9, Mr. Mbalenhle Mthethwa, on instruction of Morocco attorneys Bloemfontein. We have similarly prepared in support of the application for bail an affidavit which was commissioned yesterday. May I beg leave to hand that up to Your Worship?
Thank you.
Your Worship, if I may, the affidavit records the proceedings of today and it is done in support of this application. It reads as follows: I, the undersigned, Litam Mbalenhle Mthethwa, do hereby make oath and state that I'm an adult male businessman of full legal capacity, currently residing at number 18, Clonmore Road, Bryanston, Johannesburg, Gauteng Province. I'm a South African citizen and have been residing at that residence for a period of 25 years. The facts contained in this affidavit fall within my personal knowledge unless the context indicates otherwise, and are to the best of my knowledge both true and correct. I'm a chartered accountant by profession and a director of several companies. I had previously served as the chairperson of the Council of the University of the Northwest, and I also served in various boards and listed and unlisted companies, including the boards of the South African Broadcasting Corporation, South African Express Airways. In 2000, I established Tebe Investment Holdings, which was the first significant black economic empowerment company. I attach here to my abbreviated curriculum vitae, summarizing my background and business experience.
Switch off that phone, sir.
I have the approval, Your Worship. I'm answering.
I will then just repeat the last sentence, Your
Yes,
Worship, for the
please.
record.
Sorry for the interruption.
In 2000, I established Tebe Investment Holdings, which was the first significant black economic empowerment company. I attach here to my abbreviated curriculum vitae, summarizing my background and business experience, marked Annexure LMN 1. I'm not going to read that out. It is attached and forms part of the affidavit, Your Worship. Where I make legal submissions, I do so on the advice received from my legal representatives, which advice I accept to be correct. I oppose to this affidavit in support of an application to be released on bail should I be arrested. This was done yesterday, so the arrest of this morning was anticipated at this time, Your Worship. I'm advised that the offences with which I may prospectively be arraigned, to wit, money laundering, fraud and corruption, fall within Schedule 5 of the Criminal Procedure Act number 51 of 1997, the Act. I'm therefore advised that there is an onus on me to persuade this Honourable Court that the interest of justice permits my release on bail. I record that I make this affidavit freely and voluntarily, and have not in any way been unduly influenced to depose thereto. I respectfully submit that the interest of justice does not warrant my detention, and on the contrary dictates that I be admitted to bail. The purpose of the application, the purpose of this affidavit, is to provide the above Honourable Court with my personal circumstances and factors to be considered by the above Honourable Court as envisaged in sections 64 to 69 of the Criminal Procedure Act, At the time of making this affidavit, I've not been arrested, but my legal representative has been informed by the investigating officer that he intends to place me under arrest. I place on record that that happened this morning at approximately 7:30. I have noted in an affidavit in support of an application for a restraint order deposed to by the deponent representing the National Director of Public Prosecutions dated 14 November 2019 that it is the intention of the state to prosecute me and other directors of regiments Capital Pty Limited on multiple charges as alluded to herein before. I consequently anticipate that I may be arrested on such charges. I am therefore making this affidavit in anticipation of my imminent arrest and to satisfy the Honourable Court that the interest of justice permits my release on bail. I am further advised that the interest of justice does not permit the release of an accused person on bail if one or more of the factors set out in sections 60, subsection 4, subsections A to E of the Act are established. I will deal with these factors hereinafter. Then the heading Personal Circumstances. I was born on 15 March 1959 in Cape Town, South Africa. I've resided in the Republic of South Africa all my life, although in the past and prior to the advent of COVID-19 pandemic, I frequently traveled abroad due to my work commitments, vacation purposes, and for the purpose of visiting my sons. One was studying outside the Republic of South Africa in the United States of America. The other one was studying in Manchester, United Kingdom. They are currently in South Africa. I very regard South Africa as my permanent place of abode. I have no intention to relocate to any other country. I'm married in community of property to Mbalenhle Mthethwa, who in her own right is also a well-established and settled businesswoman in South Africa. I also own movable assets and immovable assets, which comprise of household furniture and effects, property as well as jewellery, which has a substantial value. As stated herein before, a restraint order was obtained by the NTPP against me, and consequently, my said assets are now placed under restraint. In addition to the aforesaid, I hold interest in various investments as well as shares in certain corporate entities. These are also susceptible to the restraint order. Due to the fact that the equity markets have for the past while been in a state of flux, placing a reliable value on both listed and unlisted shares is difficult. In corroboration of the foregoing, I attach here to a schedule of assets. The said schedule of assets is marked Annexure LMN2. My friends and my family reside in the Republic of South Africa. I do not have any family members residing outside the borders of the Republic. My sons who were studying in the USA and the UK have returned home. I then deal with the Section 60 of the Criminal Procedure Act, particularly Section 60(11)(b). I am informed and advised that in bail proceedings an accused person and or his legal representative is compelled to disclose whether the accused person has pending cases or previous convictions. In this regard, I submit as follows. I have never been convicted of any criminal offence either in the Republic of South Africa or elsewhere. There are no pending cases against me. Then we deal with the provisions of Section 64, subsections A to E of the Act. I do not have a history of violence and or violent behavior or conduct to be it in my personal environment or in a public domain, and this is evidenced by the fact that I do not have any pending criminal charges and or previous convictions. At present, I do not know the identity of any of the witnesses upon whom the state will rely on to prove their case against me. In any event, I have no intention to interfere with any witnesses. Should I be released on bail, I will not commit a Schedule 1 offence. Should I be prosecuted, I will stand my trial should it proceed against me. I also undertake to attend every court appearance. I am relatively well known in the Republic of South Africa, particularly in business circles. It is outside any realm of possibility that I will even think of absconding and not stand my trial. I have all the trust and confidence in the South African legal system and believe that it will be shown that I did not commit any of the alleged offences levelled against me. I was notified by the State NDPP's office sometime in November 2019 that the State intends charging me on a number of charges as specified in paragraph 4 herein above. Ever since that time, I went to the United States of America on the 5th of March 2020, and I further went to India on the 13th of March 2022, despite the intention of the state to criminally prosecute me. I still came back to South Africa. I respectfully submit that this is a reflection that I do not intend to evade and or abscond from standing my trial should I be prosecuted. I wish to record that I hold a valid South African passport with the following details: passport number A04159956, which expires on the 4th of May 2024. May I on that score perhaps just interrupt myself, Your Worship, and indicate that that passport, as well as 2 expired passports, had been handed over to Warrant Officer Kutsia this morning at the Brackendowns Police Station. I utilized the foregoing passports for purposes of visiting my son when he was overseas for business travel as well as holiday travel. Then we deal with Section 64C, read with Section 67 of the Criminal Procedure Act. I undertake not to destroy and or interfere with any evidence that may reasonably be required by the state in its intended prosecution against me. As already alluded to herein before, the identity of the state witnesses that the state may rely on for my intended prosecution are presently unknown to me. I undertake not to communicate with any of the potential state witnesses if and when the identity of such witnesses becomes known to me. Section 64D and E, read with Section 68(9). I respectfully submit that should I be arrested, that I be released on bail, as my release shall not disturb the public order or undermine the proper functioning of the criminal justice system. I will comply with such conditions as the above Honourable Court may wish to impose. I fully understand that the purpose of bail is to secure attendance of an accused person to court until finalisation of the case against him or her. Intended plea: I intend to plead not guilty to the charges levelled against me. I believe that there is no reasonable prospect of me being found guilty of any crime. Then, as far as the bail amount is concerned, should this Honourable Court grant me bail, I will be able to raise bail and pay the sum of 50,000 Rand, which amount I am informed is fair and reasonable. And then in conclusion, I submit that the interest of justice permits my release on bail, and wherefore I respectfully pray for this Honourable Court to grant me bail on such conditions as the Court may deem fit. Your Worship, if I may just, in supplementation of that, indicate to Your Worship that I've had discussions with my learned friend for the prosecution as well as the investigating officer with regard to potential future overseas travels of accused number 9, and we have agreed, and there's no objection on the side of the state, for the accused, as and when he has need to travel overseas, to make on an ad hoc basis application to the investigating officer for his passport to be released into his hands for purposes of a predetermined date of travel overseas. That is a decision that the investigating officer will take in conjunction with my learned friend for the prosecution. And if the matter is resolved at that level, there wouldn't be any need for us to approach court. If it's not resolved at that level, then we will make formal application to court for that purpose. So the agreement is that the application will be submitted to the investigating officer for his consideration. And it will be with reference to specific dates and times of travel. That is then the case for accused 9 in support of his application for bail. I thank you, Your Worship.
Thank you. Would you please stand up, Mr. Nyuna? Do you confirm as correct what is contained in this statement? It shall be Exhibit H. Thank you. An application on behalf of Mr. Mthethwa, number 11.
As the court pleases, Your Worship, it's Mthethwa on behalf of accused number 11, Mr. Mthethwa. Your Worship, we have similarly prepared an affidavit in support of Mr. Mthethwa's bail application. At this stage, we'd just like to place it on record, Your Worship, that we've had discussions with our learned friends for the state who have indicated that they will not be opposing the bail application. Your Worship, I beg leave to hand in the affidavit.
You then proceed.
As the court pleases, Your Worship, I wish to read the affidavit onto the record. It is in the regional court for the regional division of Gauteng, held at the special crime court at Palm Ridge, case number SCCC 92 of 21, the state versus Brian Mthethwa. It's an affidavit in support of bail application. I, the undersigned Brian Mthethwa, ID numbers 66122857788086, do hereby make an oath and state the following. 1. The contents hereof, save where otherwise indicated, are wholly within my personal knowledge and to the best of my belief are true and correct. I think maybe we should correct that. To the best of my belief are true and correct. 2. The provisions of section 6011B have been explained to me by my attorney. I understand that everything I state in this affidavit is admissible, it's a typing error, is admissible as evidence in any subsequent proceedings. I understand that I'm obliged to fully disclose all my previous convictions and pending cases, and that failure to do so or supply false information in this regard is a criminal offense. 3. I'm an adult male person, 55 years old, presently residing at house number 7, The Ridge, Swavel's Nest Estate, Swavelport, Pretoria, for a period of a year and 10 months. I was previously resident at number 409 Kelly Lane, Cornwall Hill Estate, Irene, for a period of 5 years. I'm a bona fide South African citizen and do not have relatives or friends outside the Republic of South Africa. 5, I'm a registered student with the University of South Africa with student number 5918561. 6, I completed the LLB degree in July 2022 and have applied for pupillage with PABASA and the Pretoria Society of Advocates for 2023. Furthermore, I intend applying to the Northwest and Limpopo bars for pupillage before their closing dates on the 30th of September of this year. 7, I'm married to Mbalenhle Mthethwa with 2 minor children, namely Ditumetse and Westu Utsile. 8, I have to provide and support food, clothing, shelter for my children and to my elderly mother, Elder Mthethwa. 8, I pay school fees of 12,750 per month for my minor children. See Annexure A, there is Annexure A attached to the affidavit. 10, I must pay electricity of roughly 11,518, and that is Annexure B, Your Worship. 11, I pay medical aid for my wife and my 2 children and 2 major children every month. 12, I have a civil judgment that was granted against me with costs. The outstanding debt relating to the costs is 420,000 rands. I pay 10,000 per month towards this cost. 13, in July 2022, I had a civil judgment, another one, against me for an amount of approximately 5 million with a cost order against me. I'm appealing the judgment and have to pay my legal costs for the appeal. 14, in the month of August 2022, I had summons issued against me for the recovery of an amount of 4,300,000 rands. I am defending this action and have to pay my legal costs for the defense. 15, I am involved in a dispute with former employers' directors liability insurance, who are refusing to assist me with legal fees for legal matters that arose while I was employed at both Eskom and Transnet. As a result, the payment of any insurance claims for any of my legal matters is not yet confirmed. 16, I receive a monthly pension of 52,000 rands per month. 17, I receive 12,000 rands per month from MKB Logistics as a director of the company, is self-employed. 18, I own the following assets, which I call my own property. 5.1, house number 7, The Ridge Street, Swavel's Nest Estate, Swavelpoort. 5.2, an Audi A4. 5.3, a Nissan Navara. 5.4, a Ford Bantam. 5.5, a Harley Davidson motorbike. 5.6, that should be 5.6, your chip, a BMW motorbike. 19, I suffer from the following conditions for which I have to take medication on a daily basis. 1, it's diabetes. 2, it's hypertension. 3, it's arthritis. 20, I understand the charges against me and the serious nature thereof, to which I intend pleading not guilty. 12.2, I know that if found guilty, the sentence to be imposed might be severe. 12.3, I am not a flight risk and maintain that I will not flee or evade trial. There is no warrant of arrest issued for me. There is no warrant for my arrest. 21, I do not harbor any resentment or ill feelings against any person involved in this matter. I will not interfere with the state witnesses and or complainant in this matter, and I will not attempt to intimidate witnesses or conceal any evidence in this matter. 22, I did not supply any false information to the police at any stage, and I commit myself to cooperate fully with the investigating officer at all times. 23, I do not have any previous convictions. A copy of my police clearance certificate dated the 16th of July 2022 is attached here too as Annexure C. 24, consequently, my continual incarceration will financially prejudice members of my family, as I make a major contribution for the family upkeep, and myself, because this matter might be disposed of after some time. 25, my release on bail will not jeopardize my safety or the public safety and the objectives of the proper functioning of the criminal justice system. Consequently, I accept that any other conditions that the court may attach to the normal bail, and I can afford an amount of 20,000 rands. Your Chief, maybe at this stage I should add that he can afford an amount of between 20 and 50,000 rands at this stage. 26, I'm not a flight risk. I have handed my passport over to the investigating officer. I intend to attend the trial until it is concluded. 27, I therefore humbly submit that taking into consideration or taking into account the aforesaid, it would be in the best interest of justice that I be granted bail. The affidavit is signed by Mr. Mthethwa and is duly attested by a Commissioner of Works. That is the case for Mr. Mthethwa. Yes, I do.
May it please the court, Your Worship. Your Worship, we have prepared an affidavit. I beg leave to hand up the original so Your Worship may follow I also intend to address the court briefly in this matter. Maybe just from the onset, I can confirm the following. The state has been in possession of a draft affidavit that is virtually the same as the one before, Your Worship, I think for the past 6 months. They've had ample opportunity to check the content thereof, and I think my learned friend will submit to the court that they are satisfied with the content of our affidavit. I can furthermore confirm for the court that my client's address was verified on Friday by Colonel Kutsia. Your Worship, we have kept the affidavit as brief as possible. I can submit that my client's personal circumstances has been part of public record for quite some time, and based on that, I think the state has decided not to oppose bail in this matter, and we have already agreed on an amount of bail. Your Worship, at the onset too, I would like to ask the court's leave not to read the minor children's names into the record. Your Worship can appreciate that having their names on the record can expose them to certain issues at school with classmates. I don't think my learned friend has any objection if I don't read the names out for the record. It is, however, there for the court to see, and the state is well aware of their details. Your Worship, I then beg leave to read in the factual aspects of this matter to the court. I, the undersigned Anosh Singh, do hereby make oath and state as follows. I'm an adult male. My place of residence is Unit 411, Kikuyu Lifestyle Estate, Woodmead, Sandton. My identification number is 73080951760887. Paragraph, the facts contained herein on the best of my knowledge true and correct, and unless otherwise indicated for within my personal knowledge. 3, insofar as I rely on allegations of hearsay, I state that I believe them to be both true and correct. 4, where I make legal submissions, I do so on the advice of my legal representatives, and I accept same. 5, I've been advised, which advice I accept, that Schedule 5, read with Section 6011B of the Criminal Procedure Act, applies to my bail application. I'm further advised that in terms of the provisions of 6011B of the CPA, and in amplification of this application to be released on bail, this Honourable Court, that I have proven that the interest of justice permit my release on bail. 6, in this regard, I wish to bring the facts set out herein below before the Honourable Court for due consideration. I structure this affidavit as follows. Firstly, I deal with my personal circumstances. Secondly, I deal with the charges preferred. And lastly, I deal with the factors listed in Section 60 sub 4. Personal information, I'm a South African citizen. My ID number is stated above. My date of birth is 9 August 1973. I'm 49 years of age. 9, my place of birth is Tongaat, KwaZulu-Natal. I attended the Emona Primary School in Tongaat from grade 1 to 6. Victoria Primary School thereafter. I obtained a bachelor's degree, Victoria Primary School from grade 8 to 9, and Tongaat Secondary School from grade 9 to grade 12. Paragraph 10, I obtained a Bachelor's of Accountancy degree from the University of KwaZulu-Natal in 1995. I also obtained a postgraduate diploma in accountancy in 1996 from the University of KwaZulu-Natal. 11, I served articles with Deloitte Touche from 97 to 99, and in January 2000 I registered to the South African Institute of Chartered Accountants. I'm a qualified chartered accountant. I'm currently unemployed. I've never permanently resided outside of the borders of South Africa. I pause to interject, Your Worship. By unemployed we mean that we are not in fixed employment. We are working as a consultant, and I deal with it later on. 12, I am married to Selina Esther Singh. Selina and the children reside in Unit 3M, Unit 00, in Flat 3M, Unit 00, Gopalal, Herbans Drive, Tongaat, a rental property. Paragraph, I reside at the above mentioned address since October 2021 for work purposes. That's the address referred to in Woodmead, Your Worship. This is a rental property. Before this, I lived at 21 Silver Sands Avenue, Wendywood. That was a property owned by the applicant, which he had to dispose of to generate fees. 14, I was previously married for 10 years to Diana Singh, with whom I share 2 children born from the marriage. My children are name omitted, a 20-year-old male. He finished matric in 2021 at St. Barnabas Remedial School in Durban North. Name omitted, currently resides with my ex-wife at 8 Ungwadule Close, Isinga Ridge, Prestondale, Durban North. Name omitted, is self-employed, and he visits me regularly. 15 sub 2, name omitted Singh, is an 11-year-old girl. She's in grade 7 learner and is enrolled at Cornerstone Remedial School in Durban North. Name omitted and myself see each other regularly. I'm responsible for paying a school fee, which amounts to 64,000 per year. I also pay a medical contribution and any other sundry expensive. Next one, name omitted. Is a 11-year-old boy born from my wife's previous marriage. He's in grade 7 learner and is enrolled as such at the Mitchford Primary School in Tongaat. He lives with my wife and we are his primary caregivers and fully responsible for him. He's financially, emotionally dependent on us. My wife and I are jointly responsible for his day-to-day living expenses. Your Worship, sub 4, again name omitted, is a 17-year-old girl born from the marriage between my wife and I. It's not name omitted, is not currently in school and stays at home with my wife during the day. She is financially and emotionally dependent on my wife and I, and we are both jointly responsible for her day-to-day living expenses. Usual paragraph 16 deals with his family situation. My mother is Sarawati Singh, an 82-year-old pensioner who currently resides at Unit CC 23-04 Phoenix View Estate, corner of 14th and Riverside Road, Noordwijk. My mother is old and frail and dependent on me for financial support. My father is deceased. I have 3 older sisters. Sub 1, Aline Broda. My sister is 59-year-old. She lives in Pretoria with her family. Sub 2, Janinti Pancham, 57-year-old. She lives in Sandton, Johannesburg. And sub 3, Bharati Naidu is 55 years old. She lives in Alberton, Johannesburg. Client's employment history is then dealt with hereinafter. Paragraph 70, I worked at the Divisional Financial Manager of SPA in KwaZulu-Natal from March 2000 to December 2002. 18 between January 2003, April 2005, I worked at Transnet SABC Limited, then known as Spoornet, as the Senior Financial Manager at Freight Rail Division. 19, during May 2005 to March 2009, I was employed at Transnet SABC as the Group Corporate Centre General Manager, Group Financial Services. 20, from 2009 to 12, I was the Acting Chief Financial Officer of Transnet, State-Owned Company Limited. 21, between 2012 and 2015, I was appointed as the Chief Financial Officer of Transnet SABC Limited. From 2015 until my resignation, I was the Chief Financial Officer of Eskom. Use of assets and liabilities, we've dealt with this hereinafter. There is currently a loan due and payable to client for monies that he loaned in advance to Dormel. The amount is 15 million. Smith & Notling, 800,000. Fabricant Pty Limited, commodities trading, there is an amount of 300,000 available. And then Investec, we've got a large amount available. Client also have a half a share in a property situated at 8 Ungunwala Close, Izipinga Ridge, Prestondale, which property is worth approximately 9 million. This property forms part of a divorce settlement. At the time of deposing to the affidavit, his share is not yet been transferred to the ex-wife. I also own movable assets. I have neither assets nor liabilities outside of the borders of South Africa. Travel documents, I'm in possession of 2 valid South African passports. I've been advised which advice I accept that I'm required to make it available to the above honourable court during procedures, which I am not opposed to do. Your Worship, for the record, I'm in possession of the 2 passports. I've already arranged with the investigating officer that I will hand it over to him. History of antisocial behaviour and previous convictions. I have no previous convictions, no pending criminal matters, and I've never been arrested. Your Worship, I then deal hereinafter with the considerations in terms of the provisions of section 64 sub A to sub E. I don't think it's necessary to read those out for the court. I will just briefly summarise. Danger to the public. We deal here with the fact that the client has no previous convictions and he does not pose any risk to the public in general or the safety of the public, and we say that his past conduct shows that he has no predisposition to commit any offences. Sub B, Your Worship, we deal with the fact that we've lived in South Africa our whole life, our family, our friends, everybody's here. We do not intend to flee, as it's not an option. We further state here that the client has strong family, community and occupational ties both in Gauteng and KwaZulu-Natal areas. He was born, raised here, and he's lived here all his life. Interference with witnesses or evidence, Your Worship, is sub C. Your Worship, of course, we are aware we assume, of the identity of certain of the witnesses, since it has to do with Transnet, insofar as we will become aware of the specific names and identification numbers of the names and identities of these witnesses. We undertake not to interfere with the witnesses or the evidence. I can also place on record that despite the fact that the client has known of this particular matter, there has been no interference and nothing alleged by the state or the police whatsoever when it comes to evidence or the witnesses. Then, Your Worship, we've got the jeopardy of the functioning of the criminal justice bail system. We state that I did not supply the investigating officer in this case with any false information pertaining to my arrest. I submit that I neither supplied the Honourable Court with any false information. Your Worship, we then go to paragraph 38, exceptional circumstances. This should actually be, I was under the impression that it was a Schedule 6. This should be not be exceptional circumstances, Your Worship. Then we deal with the interest of justice. Against the right to freedom. Your Worship, I'm not going to repeat that. That is legal submissions that's made to the court. Your Worship, the client has signed it and it was duly commissioned today. Your Worship, I've got a few submissions to make to the Honourable Court. As I've already indicated, Your Worship, my client was aware of the fact that these charges will be preferred against him. In fact, in September of 2021, when this matter was first placed on the roll, the state provided the then accused with a charge sheet, and in the charge sheet my client's name prominently appeared. Your Worship, if my client wished to at any stage evade justice or evade this trial, it would have been easy for him to do so. He has always, he said so under oath in the Zondo Commission, and he still maintains that he intends to prove his innocence against any of the charges that's preferred against him. Your Worship would recall, and I think the state is aware of the fact that he gave a proper version, and he worked together with the Zondo Commission to give his side of the story, if I could call it that, insofar as it relates to any of the Transnet offences that will be preferred against him. Your Worship, we have been provided, I have been provided, and I've provided same to my attorney, Mr. Mbalenhle Mthethwa, of a provisional charge sheet. I do not know at this stage if the state intends to keep the charge sheet as it is or whether it still intends to amend it, but we know of the content thereof, Your Worship. As I've already stated, we intend to plead not guilty to those particular charges. Your Worship, we have arranged an amount of bail, of course, if the court is agreeable to that. That's the amount of 50,000. Your Worship, part of the conditions will be that my client hand over his 2 passports. As I've already stated for the record, that I will do so today. Your Worship, as part of his conditions, we would similarly, as with one of the previous accused, place on record that if we do intend to do any travels outside of the borders of South Africa, that we would be placed in a position to arrange same with the state and the investigating team in this matter. The normal arrangement is that you provide the state and the police with an itinerary, the ticket, etc., and that it's then inter partes arranged between the parties. Your Worship, I do not think it's in the interest of justice to bother the court with such arrangements, unless, of course, same is opposed at the end of the day. Your Worship, I respectfully submit that we have made out a case. The state has had the opportunity to verify all the information in our bail affidavit for the past 6 months. Since they've had a draft, we've made out a case that it's in the interest of justice that our client be released on bail. May it please the court, Your Worship.
I do so.
The court pleases, Your Worship. The state is not. The court pleases, Your Worship. The state confirms the exhibits, all the exhibits from the accused, as handed in the court record. And I further wish to state that indeed the state has confirmed the properties, the addresses of the accused, as well as whether they are flight risk or not. At the moment, one of the things, when I started, I said the state is not opposed to the release of the accused. It was on the basis that after perusing all the information that were provided to us by my colleagues on behalf of the accused, we couldn't, and on our side as a state, we couldn't say that the accused before the court are flight risk. I will therefore submit that the court can grant the accused bail. We, myself, or the state as well as the defense, hadn't come up with the actual amount, but most of the accused that appeared before this court are on bail of 50,000. We see it fit that if the court can consider that, I'm quite aware of the fact that the court has the powers to impose any amount, but I think it would be fair that the accused are treated the same as the other accused that were already excused by the court, as the court pleases. The conditions that we are looking at is that the accused avail themselves on any possible date that this matter is postponed to, and that their passport has already been handed in to the investigating officer. If any of the accused intends traveling overseas, then he will have to make the necessary application via the investigating officer. Then we will bring it into the attention of the court, as the court pleases.
Mr. Group for number 8. Any further submissions?
Thank you, Worship. The application for accused number 8 and the remaining accused before court, Your Worship, is that accused number 8 falls under the ambit of Schedule 6 of the Criminal Procedure Act, given that he has a pending matter, Your Worship. Your Worship, I submit that the fact that the state is not opposed to the accused release on bail, as well as the fact that the accused has availed himself and has cooperated with the state and the South African Police Services at all times, and that he is out on bail in the other pending matter and has successfully attended that matter, which is currently under review in the High Court. Whether the NPA is going to prosecute the matter or not, Your Worship, indicates the existence of exceptional circumstances, Your Worship. His personal circumstances are also before court, and he has also been aware and has cooperated with the state at all times in this matter, Your Worship. Further to that, this current matter, Your Worship, predates the pending matter, which he is currently released on bail, Your Worship. Accordingly, I submit that the existence of exceptional circumstances have been proven by accused number 8, Your Worship, and that he should be permitted to bail or released on bail. Your Worship, in accordance with what my learned colleagues have indicated, he has made provision for an amount of 50,000 rand, which he has raised through loans by family members and friends, Your Worship, given that he is currently under curatorship, and that those funds are available to pay bail in the amount of 50,000 rand. Your Worship, he has also surrendered his passport to the investigating officer, and in the event that he is required to travel overseas, he will make an application to the investigating officer as indicated by my learned colleague for the state, Your Worship. That is in the case for applicant number 8.
May it please the court, Your Worship. I respectfully submit that a proper case has been made out on behalf of accused 9 to demonstrate that the interest of justice does not warrant his further detention and that he should be released on bail. We have indicated to Your Worship that he has got an amount of 50,000 rand available for bail. In the face of no opposition by the state, we submit that Your Worship should consider granting accused number 9 bail as proposed. We believe that there is no need for any special bail conditions and that the standard bail conditions should simply be for the accused to attend court and remain in attendance until his case is finalized. Then there's only one additional matter, and that's the issue of the passport. I've placed that on record. May I request for Your Worship to consider making an order that would allow for accused 9, as and when he has need to travel abroad, to make application for the release of his passport with the investigating officer, who would then consider it, so that there is no need to bother this court with unnecessary applications on that score. Those are my submissions. If your worship is to be so inclined, I would therefore seek for the court to grant accused number 9 bail as just submitted. Thank you.
Worship, there's... Oh, sorry, Mr. Bully. No.
As the court pleases your worship, I wish to submit that we have, or the statement that the accused has made is sufficient, your worship, for the accused to be released on bail. We have demonstrated, your worship, that it is not in the interest of justice for the accused to be incarcerated during the trial, which might take quite some time, your worship. We have also demonstrated to the court, or through his statement, your worship, that he will not interfere with the criminal, or let me put it in this way, your worship, that he will not interfere with witnesses or anything, or do anything that will compromise the criminal justice system. Your worship, it is well known that Mr. Mthethwa is currently a pensioner. However, he has, your worship, been studying during the past few years. He has completed his LLB. Your worship knows that, you know, being a people is in actual fact a struggle. During that period, the income that he will be generating will not be as high as he used to earn, your worship, that these two must be taken into consideration. He has raised an amount of 20,000 rands at the moment, your worship. However, he has promised me that he can be able to borrow from family and friends a further amount, say up to 50,000, your worship. So I submit that your worship should take that into consideration. The fact that he's earning a pension which is much less than he had expected, and that he is self-employed, roughly earning about 12,000 rands a month from his other employment, and that he will be saving a pupillage, your worship, and saving pupillage is not that economically glamorous, let me so say. Your worship, that is the case for accused number 11.
No, I've got nothing more to say except, Your Worship, I think an appropriate order would be in respect of the travel, that if in the event that any of the accused wishes to travel outside of the borders of South Africa, that same must be arranged with the investigating officer, and that it's within his purview. Because normally the court orders that they're not allowed to leave the country, but I think it's more appropriate under these circumstances that the court say if they leave the country they should get the permission of the investigating officer, and that same should be arranged with him. As my learned friend said, it makes it easy, and then it's no need to come to the court every time in such an event. May it please the court.
You say you've got 2 passports?
Yes, we've got 2. I've got them with me. I will definitely hand them over, Your Worship. For the record, I'm handing it over, Your Worship, to Colonel Kutsia.
I take it the date of postponement is the 14th of October as arranged with the other accused.
That's indeed so, Your Worship. I just need to place the following on record. I was present in court when my learned friends for the previous accused 1 to 7 addressed the court on the issue of what should happen at the next court date. I've got one other aspect that I think we need to deal with. I do not wish to place my learned friend in a predicament or place him in the hot chair right now, but I would like him to confirm for the record that the investigation in this matter has been completed. So I don't want us to come here on the next occasion, Your Worship, and the court is then informed that there's still further investigation that's needed. So it's very important that we all are on the same page pertaining to that issue. The state must confirm that the further investigation in this matter has been done, and it's for that reason that they have agreed that this particular matter can then, that disclosure can take place, and that we can then also get a copy of an indictment or a charge sheet. And that the matter on that day, that dates will be arranged for trial. May it please the court, Your Worship.
So in short, you want to know whether or not investigation is complete?
Indeed, Your Worship. And of course, we are entitled, in fact, Your Worship is entitled, if they say, well, they still need to do further, let's just hear what the investigation is. Because the state has agreed to postpone the matter to the next occasion, provide the docket and provide the indictment or charge sheet. So let's just all be on the same page. May it please the court.
Thank you. Advocate Bakamela?
As a court pleases, Your Worship, I thought I would address it broadly, the aspect that my colleague is raising. When I asked the court to grant the state a postponement, I said we need to finalize our investigation, and part of finalizing the investigation is to join those outstanding issues that are still outstanding. That is investigation. We are not joining them simply because the investigation is complete. Sometimes when the police interview some of the suspects,
Something comes up.
Yes, and something new comes up. So it will never be that we'll come to court and say we are ready, the investigation is complete. But what I guaranteed, I confirmed to this court, is that we will be able to provide my colleagues with the indictment, as well as disclose the relevant docket or evidence that is applicable to all the accused. So it's a little bit difficult for me to confirm that investigation will be complete or is complete, but the defense will be in possession of the contents of the docket when we come back on the 14th, Your Worship, as a court basis.
Your Worship, may I be permitted just to address the court on this particular issue? That's exactly the predicament that we find ourselves in. If the state intends to join further accused, then the state must play open cards with the court and say, listen, we're still going to join accused, and it's let's speculate for a single second. It's the people that's sitting in Dubai, the Guptas, for which they brought extradition applications, which places this whole matter in a totally different context, Your Worship. The state has elected to issue warrants of arrest and arrest the accused today and bring them before court. The case law is clear. If you bring people before court on a warrant of arrest, you must be ready to proceed with trial. And that is exactly what we want to know. The state cannot expect us at this stage, if their intention is to still join the Guptas for whom they applied to be extradited to this country, that we should sit here and sit on our laurels for the next year or 2 or 3, as long as that's going to be. Your Worship, and I really think it's important that my learned friend takes this court into its confidence and tells this court who they intend to join. Because if that is the situation, then we know to be ready on the next occasion and serve the necessary notices and make sure that the state either then postpones for trial or they argue the matter so that we can argue the matter, and the matter is then struck off the roll so that they can get the house in order, get the other accused extradited, and if and when that happens 3 years down the line, then the matter can be brought before court again. Right, please, the court.
I understand what you say, but your client is making an appearance for the very first time today.
Yes, Your Worship, we understand that.
Yeah, and then that being the case, the prosecutor says, what I can say for a fact is that I am going to join other accused. There are already 2 whose names are there on the charge sheet, but who the prosecutor explained as of now, they are not here. Now, an undertaking from the state is that definitely by the 14th, you'll be provided with the contents of the docket, and then provided with the charge sheet.
Yes.
On that aspect, the prosecution is very clear.
No, quite happy with
now,
that.
in the light of that, if on the next occasion they cannot set the matter down for trial for whatever reason, then whoever will be presiding will have to deal with that matter at that particular
stage. That is the
stage.
only issue that I wanted to place on record, Your Worship, that the state understands our position, that they're not caught off guard on the next occasion. As Your Worship quite rightly said now, on that day, we need to deal with that particular issue then. May it please the court.
Thank you. Will the accused then stand up? After considering the evidence as per Exhibits G, H, I, and J, and after considering the submissions by the legal representatives of the 4 accused, being the applicants as well as the state, the court is of the view that it will be in the interest of justice that the 4 accused or applicants be admitted to bail. The application is therefore granted and bail is set in the amount of 50,000 rand for each of you. The bail conditions are that you appear in court on each and every day to which the matter is postponed, starting on the 14th of October this year and on any other subsequent days thereafter, and you remain in attendance until you are excused or given the dates for the next appearance. Another bail condition is that your passports will all be held by the state, and whoever needs the passport to travel will have to make the necessary arrangements with the state, that is the prosecutor and the investigating officer. Whoever is released on bail and fails to adhere to any of the bail conditions will have a warrant issued for his arrest, and then he'll be held in detention until the matter is finally disposed of, and your bail money will also be declared forfeited to the state. Do you understand that? Your date for the next appearance, 14 October, 8:30 in court number 9. May stand down.
May it please the court, Your Worship.
Court, Your Worship.
Your Worship, are you going to do a short adjournment at this point?
I'm going to take a short adjournment.
I think it would be prudent.
Court adjourned. If they're going to pay, I'm just going to make an endorsement.
All right, Anoj Singh and Brian Mthethwa there granted bail of 50,000 rand in the Transnet matter. The state has basically said that they're amenable to them being granted bail because they don't believe that there would be a flight risk. And basically the conditions are that they and the other two people who are in custody must ensure that they hand over their passports to the state, which it seems they've done already. And they must also turn up for any court dates that have been organised. And of course, the judge there saying that the next court appearance will be on the 14th of October at 8:30 a.m. And of course, we're going to be continuing to cover this story as it proceeds.